Yeah, that's a kiss of death. He shouldn't have said that.
Well, it's 9 o'clock, and let's call the meeting to order for the Tennessee Auctioneers Commission for October 7, 2013. If you would, Susan, call the roll, please.
Bobby Colson.
Here.
Ronald Collier. Here. Gary Cunningham. Jeff Morris.
Here.
Howard Phillips.
Here.
Mr. Chairman, you have a quorum.
Thank you so much. If you would, read the notice of meeting, please.
This meeting's date, time, and location have been noticed on the Tennessee Auctioneer Commission's website, included as part of this year's meeting calendar since August 8, 2012. Additionally, the agenda for this month's meeting has been posted on the Tennessee Auctioneer Commission's website since October 25th, 2013. Further, this meeting has been noticed on the tn.gov website.
Thank you for that. We have in front of us an agenda for today. If you would take a look at that, gentlemen, and we need to adopt and review and adopt that agenda for today.
I'll make a motion.
By Howard and seconded by
Second.
Bobby. All in favor say aye.
Aye.
All right. Next item is to review the minutes from last month's meeting, if you've had a chance to do that, and they are in our book, I think, or not?
They're on your iPad.
On the iPad. All right. So, guys, if you go to your iBooks there. Where are you there?
Yep, it's iBooks.
Have a tab.
iBooks.
Second time I've ever saw one.
There you go.
I could take a moment to remind you as well to be sure when you speak to pull the microphone down so that we capture.
Other than mumbling, we will do that.
I make a motion we approve the meetings. Sorry. I second. The minutes.
It's been moved and seconded that we approve the minutes as written. All in favor say aye.
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 All right, perfect. All right, guys, if y'all would pass that around for your approval. Next, we have anybody. We don't have anybody from the Nashville Auction School today. We'll get up right into the legal report, Julie, if you'd like.
Okay, I'm ready.
Okay.
Right.
And that's going to be tab 2.
Y'all just let me know when you found it.
Found tab 2.
Yeah.
Tab 2. Oh. Okay, go right ahead.
Ready? Okay, the first one is 2013009931.
Respondent firm conducted a personal property auction for complainant. After the auction, complainant states that respondent's principal auctioneer told complainant that one of the auctioneer's family members bid on a diamond ring and several other items and did not have money to pay, and asked if complainant could wait until later in the month for payment. Complainant states there was a $750 reserve on the diamond ring. Complainant states that the auctioneer told complainant that the auctioneer would pay complainant after all money was collected. Complainant states that the auctioneer let the family member leave with a box of gemstones and another ring without payment. Complainant states that the auctioneer tried to prosecute the family member for theft, and a police officer returned the ring to complainant but said the gemstones could not be found and no arrest was made. Complainant states that respondent's auctioneer paid complainant some money, but there is a remaining balance which respondent's auctioneer refuses to pay. Complainant states that a police officer said that respondent's auctioneer resold the diamond ring and other items at another auction. Respondent's auctioneer states that complainant has been paid in full, noting that respondent sent complainant an additional check for $139.70 with the notation auction paid in full, which complainant cashed. Respondent's auctioneer admits that a family member did not pay at the subject auction, and the auctioneer has banned the individual from respondent's auctions and filed a police report. Complainant submitted correspondence from respondent's auctioneer to complainant stating that some items were sold at another auction, and complainant would send information about how much the items brought and the commission. In the correspondence, respondent's auctioneer states that respondent took a loss and could not take more. Respondent's auctioneer also states that pursuant to the terms of the auction, pursuant to the terms and conditions of the sale, if a purchaser does not comply with the terms and conditions, respondent can cancel the sale and sell all items at public auction without reserve, with any purchaser being liable for any deficiency in costs. Complainant also attaches a settlement form from respondent which appears to outline the money brought in at the original sale plus 2 additional sales, deducting respondent's expenses, including gas and commissions for items sold on 3 separate dates, as well as commission for items which were not sold, and leaves a balance owed to complainant of $139.70, which was sent to complainant and cashed. Complainant states that complainant did cash the $139.70 check because complainant also took a loss on the diamond ring that complainant had placed on reserve for $750, which complainant states was later auctioned for $300 in gemstones. Respondent's auctioneer sent the contract and final settlement. Respondent's auctioneer states the complainant was sent the final statement showing the revenue and expenses along with the additional $139.70 check marked auction paid in full, and by cashing this check, complainant agreed with the final settlement. Respondent's auctioneer attached a copy of the contract, which the auctioneer states does not mention any reserves. Upon examining the contract, it does not appear to specifically reference any reserves, but states that the auctioneer has the right to sell the property described as personal property, and the right to sell the property includes the right to sell the above described property at public auction to the highest bidder on the premises on or about April 5th, 2013, or up to 60 days after said approximate date. Respondent's auctioneer states that a family member did not pay a bill, and respondent ate the cost of that. Respondent's auctioneer states that complainant removed numerous items before the sale in gemstones, and no money is owed to complainant. Legal counsel contacted the police detective who handled the police report. No one was prosecuted as the matter was determined to be a civil one. The detective stated that one ring, not the diamond ring, was recovered and returned to complainant, and respondent's auctioneer told the detective that the auctioneer resold the items won but not collected by the family member at another auction for $600. The detective was told that the diamond ring that originally sold for $750 was sold for $300, and the auctioneer said he would have to pay complainant the difference. Respondent's auctioneer was contacted by legal counsel and asked for documentation regarding the items sold at 3 auctions referenced in the final settlement and an explanation for the gemstones and diamond ring. He initially expressed cooperation, but then sent an email stating that all files were destroyed in a flood, the complainant was paid in full, and stating that he was back in another state and the firm was closed. The recommendation is a consent order for voluntary surrender of respondent's firm license for violations of Tennessee Code Annotated Section 6219 112 B4 and B12.
They did not make a claim against the fund for any differences that they said they were owed, did they?
There's been no civil lawsuit at this time. I believe when I spoke with the complainant, I made sure that the complainant understood that any action that the commission took, we could not demand return of her money or go in and get her money, but she could file suit. She said, well, is there anything I can do that can help me? And I gave her the information, told her if she chose to file suit, her attorney could contact me. I could point him to the provision in the law about that. But at this time, there's no civil litigation regarding.
That's small dollars. It'd be hard to have a civil case, As the auction company, have they agreed to voluntarily surrender their license?
Well, the email was not one that was very open to me responding and and contacting him back, but it basically said, let the Auctioneer Commission do what they want. I'm back in another state, and this firm's closed. It is not closed in our system. I don't think they've turned in anything. That was the reason for the recommendation. If they're back in another state anyway, then they should have no problem surrendering this license.
This auction was held in this state.
It was.
And now he's just took off, it looks like,
According to what I was
as far as what
told.
we can tell.
As far as what I can tell.
You asked for his firm license?
The complaint was only opened against his firm license. We'll get into this next, but we also have a second complaint against him personally along a
Want to
similar
consider
nature.
these separately or together?
If you'd like to defer a determination on this one till you hear the second one, we can do that.
If
My
it's the same
recommendation
case.
is the same for the second one.
Okay, well, let's go ahead and let's listen to the second part of it. And then
Sure, and we can just
If you
come
guys
back.
are okay with that.
I think it'd be a great idea.
I don't think that we ever should consider a firm license suspending somebody's firm license without you know what was going on with the auctioneer.
Right. Well, I think that's part two here.
If you'd like me to go ahead and do the second one, we can come back to this one.
That'd
Be great.
Okay. I didn't join them together because they're largely fact intensive, and I thought they would get confusing. That's the reason that I didn't
Okay.
do that.
All right.
2013-013531. Complainant alleges that respondent, auctioneer, this is the auctioneer for the respondent firm referenced in the previous complaint, but a new complainant, auctioned furniture and personal property from complainant in May 2013, but has not paid complainant and will not return complainant's telephone calls or emails. Respondent states that complainant signed a contract stating that all items were free and clear of encumbrances, and respondent later discovered that the items were financed. Respondent states that respondent was contacted by a bank representative who told respondent this. Respondent states that complainant has returned the final settlement, but respondent has not heard back from the bank, and respondent does not know who to pay now, complainant or the bank, and this is the reason for the delay in payment. Respondent attached no documentation. Complainant sent additional information stating that complainant filed a police report with the local police department around the time of filing this complaint. Complainant attached a copy of an email from respondent to complainant on the same date, just prior to respondent submitting his response to the complaint, which states that respondent's firm is closing on July 13th, 2013, and complainant would receive complainant's money in 45 to 60 days. The email also states that complainant signed a contract stating that everything was free and clear of liens, and complainant would receive the money in the time allotted. Complainant states that respondent's statements regarding a bank are false and that all property was complainant's property and no bank had contacted anyone about liens. Complainant again sent information in September 2013 stating that respondent was still in full possession of the money received for auctioning the items in May 2013, which totals over $2,000. Complainant states that although respondent stated he was closing his business, respondent is still auctioning. Respondent was contacted by legal counsel requesting documentation regarding the subject sale, including information about the bank which allegedly contacted respondent. Respondent initially appeared cooperative, but then sent an email stating that all files had been destroyed in a flood, that respondent was back in another state, and the firm closed, and indicating the respondent would not discuss the situation any further. The recommendation for this matter is a consent order for voluntary surrender of respondent's auctioneer license for violations of Tennessee Code Annotated Section 6219, 112B4 and B12.
So now we're saying it's basically the same auction, same complainant.
Different complainant.
Different complainant.
Different complainant. These are two different people that
Okay.
say that these things have. That's why I said at the top, but a new
I got
complainant.
you. All right.
This respondent is the individual. The previous respondent is that individual's firm that he's the principal auctioneer for. Both auctions involve the same two parties, the same
One
auction
was in
and the same
April and
auctioneer.
one was in May.
That's correct.
One
So
was for a ring, one's for this $2,000 worth of personal property.
ring and gemstones, and then this one's furniture and personal
Right,
property.
okay, I got you. I got you. So he's got a history of not paying his customers for the stuff that he sells.
And as you can see, he was first licensed in September of 2012, so he's not been licensed very long. But like I said, based on the correspondence,
Licensed in another state?
he came in through reciprocity through North Carolina, I believe it was.
Well, we don't want him doing any more business in Tennessee until all these things are straightened out, obviously. So, you guys have any questions about this?
I have a question. Why would we ask him to voluntarily surrender his auctioneer license? Why don't the commission, I'm asking a question, can the commission make a recommendation to suspend his auctioneer and firm license?
Well, the reason why it says voluntarily is it's a consent order at this point that he's signing. We can do voluntary suspension or voluntary revocation. I did the voluntary surrender because he indicated he was leaving and not coming back. So that was the reason for that recommendation. The reason the voluntary language is in there is obviously he would be signing the consent order, agreeing to the surrender of the license.
In the past, when people have voluntarily closed down and left, they usually pop up in another county or down the road or across the mountain somewhere doing the same thing.
I mean, at this point, he has a license. We would have to take that as unlicensed activity at that point. I mean, I just thought, considering the nature of it, you know, and him representing he was in another state, you know, this was the most action we could take rather than levying a civil penalty against this person. That was the reasoning behind it, but you all are free to.
If he doesn't sign the consent order,
It would go to a formal hearing.
okay.
The easiest way is him to voluntarily and sign the consent order and agree to do it. That's the
And
quickest, simplest,
Commissioner
less costly
Phillips
way.
is correct. He could pop up somewhere else, or he could be back in another state. I don't know. All I know is when we spoke on the phone, he appeared cooperative, and then when I sent the email confirming my questions, I got back nothing and not any amount of cooperation. So,
Well, I think we know what we want to do, don't we?
It sounds like this is a path of least resistance to start with. Is
what did you say?
the
I'm
path
sorry.
of least resistance to start with.
Well, and if he did
Quickest
come
way.
back to want to apply again, you know, because he'd
He'd
be
be
surrendering,
flagged.
he'd be flagged to have to come in before you all.
Whenever,
again.
let's say, on a deal like this right here, and we do he ends up volunteering his license and all that stuff, do we send, and you said this was a reciprocal,
Yes, it was
Do-
obtained, I think.
do we send notice to the state where he resides or where his other license are, other states that he's licensed in?
We could send a copy of the consent order at that point.
Yeah, I didn't know if we
I
did
think
that.
that'd be advisable. You want to make a motion, Bobby? on
Yeah,
this?
I would move that on, was that 1 and 2 there?
Yeah, 1 and 2.
Complaints 2013-00-9931 and 2013-013-531 to go with legal's recommendation.
Is there a second to that?
I hope I got those numbers right, but Susan will if I didn't. So.
The first and second matters on the legal report. We know what you mean.
Second.
Is there a discussion, Howard?
I'd like to know how much time does he have to surrender these licenses?
30 days from the receipt of the consent order is what is typical. They have 30 days to settle the matter that way, and then it's forwarded to be put in line for litigation after that point.
This
It's sent by certified mail.
This complaint is small change, but it's one of the worst complaints that the auctioneers can have, is cheating people out of money.
Correct.
And I don't like it, and I don't think that if they do it one time, my personal opinion is they should never have a license.
I agree, and the only thing is whenever I first looked at it, and I was thinking that he ought to be able to defend himself a little better, or I'd be looking for asking more questions to it. Then when I get down to the end and see where he's hadn't even tried and done took off, he's.
Well, I did try to get more documentation.
Oh, I know. I'm
and
talking about.
that's what I was
I'm
thinking.
talking about if I was him, I would have been doing a whole lot more. But when he didn't even try and then wasn't very cooperative, I agree with Howard. It's just. I'm like Howard. I just hope. I think the quicker we move, the better we are.
Right.
Because you don't want him somewhere else.
It's been moved and seconded. All in favor say aye.
Aye.
All against say no. Motion passes. Item 3. 4, it looks like.
3 and 4 are together. 2013-013-551 and 2013-013-561. Complaints were opened against respondents. Respondent 1 is a licensed auction firm and a licensed real estate firm. Respondent 2 is unlicensed with the Auctioneer Commission, but is a licensed real estate firm. Based on an anonymous complaint which included 2 advertisements for 2 real property auctions. The anonymous complainant states that the auction firm number for Respondent 1 is not included on the advertisement. One ad references that 2 lots will sell absolute, but does not identify which lots in the advertisement. Respondent 2 is shown as co-broker and is unlicensed with the Auctioneer Commission. One ad references an opportunity to buy at your price, and not everything is being sold absolute. The name of the auctioneer for Respondent 1 is not displayed as it is on that individual's license, and Respondent 1's website does not include its auction firm number. Respondent 1, who is principal auctioneer of Respondent 1, as well as a licensed affiliate broker, submitted a response on behalf of respondents. The individual is the auctioneer/affiliate broker who was advertised as conducting the sale for Respondent 1 in both advertisements. The individual states that he has been auctioning for many years in several states and has never had a complaint, but takes the matter seriously and wishes to correct any violations that may have occurred. The individual admits that one ad references 2 lots selling absolute, but does not specify which ones, and states that this was the only advertisement, did not have this specification, and was meant to be included on this particular ad. The individual also states that the wording about buying at your price is simply wording that has been used to entice buyers to attend, and the individual was unaware that this is unacceptable wording. With regard to no firm license listed on the ads, the individual whose auctioneer license number is listed on the advertisement states that he did not realize the firm number was also to be included, and both license numbers will be utilized in the future. With regard to listing Respondent 2 as a co-broker, the individual states that the reason Respondent 2's name was on the ad was because Respondent 2 referred its client to Respondent 1 to handle the auction, and Respondent 2 had no part in the auction or in the advertisements, but was only listed as a courtesy. There appears to be no evidence of unlicensed activity on the part of Respondent 2. For Respondent 1, the only violation appears to be that the auction firm license number was omitted. The firm name was listed, and the individual recognized the mistake and stated it will be corrected in the future. My recommendation, based on this information, was a letter of warning regarding Rule 0160-01-.20, which references advertising.
Are there any questions regarding this case?
What was the part about absolute auction not being advertised?
The advertisement said, I want to get this right. Look at a lot of advertisements between this and real estate. The advertisement said auction in big letters at the top. It was for real property. One of them consisted of a number of lots, around 30 or so lots. It talks about where it's going to be, how many lots total it's going to be, the date and time, and underneath that, in smaller font, not the largest font on there, it says 2 lots will sell absolute. What the person was complaining about was that it did not circle the 2 specific lots that were being sold absolute. It just said that 2 of the 30, 40-ish lots will be sold absolute, and did not specify on the advertisement. It had a map of
I don't
the
know
lots.
that they have to specify
I
those
couldn't
lots.
find in the
We do
rule that
all
they
the
had to.
time.
There's something about font size. If some will sell absolute and some will not, the font
Right.
size has to be the same. But actually, the absolute language is much smaller than the fact that it just says auction. So I did not see an issue with that. However, there may be something I'm not aware of. But
we do auctions all the time.
that's how it was laid out. Does that give you
Yeah.
a better idea of the layout of what I'm talking about? I know sometimes it would be easier for y'all to see it, but it's just sometimes too hard to redact everything. I would
Right,
have to.
right.
So
I don't have any problem with that. That's
No,
pretty
not
normal
if-
for us.
Not if it didn't specify something's absolute
Right,
sale.
right. Any other questions? You want to make a motion?
Make a motion, we accept legal's recommendation.
Second, please.
Second.
Seconded by Bobby, made by Howard. All in favor say aye.
Aye.
Against? Motion passes. We're on item number 5, I guess.
there's only 4 this month. We've
Only
got
4,
rules
so we're
stuff,
done.
so it's a pretty light.
All right, so that's
Light
the end
report
of that.
this
All right,
month.
perfect. Yeah, you're going to get into the rules
I
that
don't
we-
think I'm next. I mean, if you all would like to change it and go ahead with that, we can, but I think I'm actually the last thing before the unfinished business and commissioner
Well,
reports. so.
Well, Bill's not here yet to talk about the budget. Is he going to come in and do that?
Yes, he is going to come. He was delayed by a phone call, and he's actually appearing at the cosmetology board meeting prior to coming here this morning.
Right. So I think we go right into the rules thing and then give him some more time to get here, if that's what you.
That's fine. We could do the rest of the administrative report or the rules, either one.
It's up to you all.
Let's go right into, let's get the rules out of the way, and then we can get into the administrative
That's
stuff.
Tab 5, and I actually have an additional handout that wasn't ready.
Notice of rulemaking. Here we go. Look at you. Man.
That would be a little much.
It will be.
This is what we're going off now.
We're going to be looking at that, but also this. I didn't want y'all to be flipping between two books. That's just.
So we're going to flip between iPad and paper, right?
Right.
I got you.
Okay. Did you all have an opportunity that we're looking right now at the notice of rulemaking hearing on your iPads? This is what you had looked at last month. Susan sent it out about a week ago. There were just a couple minor things with some wording about, how we amend things that were changed. Nothing substantive to the rules. We looked at these. We've been looking over them over the past couple months, but I handed them out last month to everyone to specifically look at to see if there was anything we wanted changed at this point before we move forward with noticing this for a rulemaking hearing. So first, I'd like to talk about if anybody had any recommended changes to the substance of this notice of rulemaking hearing.
Why don't you just kind of walk us through, if you don't mind,
Okay?
just go through it page by page and just tell us what we're looking at and kind of what we need to be
Okay.
considering.
I'll summarize them because, basically we went through these. If everybody knows but Commissioner Collier, we started this out as, here's things we want added to the rules. So some
Right.
of them were me going back in and figuring out if it would work best as a new rule
Right.
or as an amendment to an existing rule. So that's why you're looking at it how it would be in our rules, if they are enacted, instead of just bullet points like we started out with. The first matter was you all had expressed concern about the requirement that if someone has a gallery license, there is a requirement by statute that a licensed auctioneer shall call all the auctions. You all thought that in addition there should be something addressed in the rules that an auctioneer should have some kind of responsibility for making sure if he goes to call auctions at a gallery, that the gallery is licensed, because we have had complaints of unlicensed galleries. They come around fairly often. So
that number 2 is right
number
there.
2 is addressing that concern, and I added it to an existing rule entitled Duties of Auctioneer because I thought it currently only had one paragraph. I thought it would be a further duty of an auctioneer. So it would be an amendment to Rule 0160-01-.01, adding it as a new paragraph 2, stating that no licensed auctioneer shall accept offers for hire to call bids at any auction held by an auction house, auction barn, or auction gallery if the auction does not hold a valid gallery license pursuant to the provisions of Tennessee Code Annotated Section 6219-125.
It says, or auction gallery if said auction does not hold. Does that not, should it have another word behind it that says auction?
I called it auction because if it's an auction, I was thinking if it's an auction house or an auction barn, they all have gallery licenses. There's no separate one.
I have a building and stuff in it, and I want to hire Bobby Colson to sell it. And I decide then I want to have auctions, and as long as Bobby has a Tennessee auctioneer license and a Tennessee firm license, he couldn't do that sale because he would have to have a firm license for that location. Is that correct? Or a gallery license? I'd have to have a gallery license.
I think this
I don't think so.
this refers to people that are doing auction galleries where they're taking consignment goods from
And-
multiple people.
And they're still handling the money and everything like that, and they're
still
just bringing
handling
somebody
the-
to call it.
It's not Bobby.
We've kind of got it in reverse in the statute for the gallery owners, but at the beginning of the discussions, they also said, hey, we should have this auctioneer checking for a license if he's going to come in here and call bids too.
You would be handling the money. You would just be hiring Bobby to call the bids. And that's-
Right, a little bit
that's-
different than what you were describing.
And it all gets down to who's handling the money.
I'd probably hire somebody better than Bobby, but
Do y'all want me to move on to the second one?
Yeah.
I'm good with that.
We went through lengthy discussion, and Commissioner Collier, you weren't here for this, but there was some confusion over the statutes referencing a firm's principal auctioneer versus the word sponsor as used in the statutes for a sponsor of an apprentice as opposed to a sponsor of an auction company. This is the only existing. We decided to move forward to make it consistent with the statutes to refer to it as a principal auctioneer and lay out its duties. This was the only rule that referenced what we would now refer to as a principal auctioneer as a sponsoring auctioneer. So I recommended, the recommended change was to make everything consistent and change it from sponsoring auctioneer to principal auctioneer, since that's the wording we're moving forward with. Just a little housekeeping because it's the only rule that had referred
And,
to a
and our
sponsor.
thought process was we were trying to tie it to the language for real estate companies as well, where they have a principal broker that operates that real estate company. We were using the word principal auctioneer that operates that auction company.
And then also you all's specific, the auctioneer statute for licensing only references someone being there as a principal as opposed to a sponsor. So it's actually really directly as an attempt to tie to your particular licensing statute. So that was just a cleanup to address that issue, which we'll come to down the road. The next one is a civil penalties rule that we already have, but some alterations to add in. You'll see the underlined portions are the additions. The present civil penalties rule does not allow specifically for a civil penalties range for violation of the gallery license statute. That's 6219-125. So this is added in a civil penalty range for
A and 125B. Right.
what did you say? I'm sorry.
125A and 125B.
A says that any person that desires to own an auction house, barn, or gallery for the purpose of selling consigned goods is required to obtain a gallery license.
Right.
We can, since Assistant Commissioner's here, do y'all want to hold off on this and come back to it?
Let's just go right through this.
Okay.
These few pages here.
The
real quick.
addition is basically to address a specific civil penalty range for violation of that statute because it wasn't in there. In addition, if we have somebody that signs a consent order, for example, agreeing to do something and doesn't do it, added in a civil penalty range for violation of any commission rule, any of your rules, or an order that you all have given out, allowing for violation of that. Also, by statute, you're permitted to assess a civil penalty with each continued violation each day can be a separate violation. I thought that would be good to add. And really, it's just renumbering the rest of it to add that in up closer to the top for clarification. The next matter is a fees rule that we had. Subsection 6 used to say, or currently says, any notification of change of information pursuant to Rule 0160-01-.24 made more than 60 days after the effective date of new information shall result in a civil penalty of $100. I talked with staff. Apparently, that's not something that has been the practice, and I think the more appropriate way to approach that would be going through it where if we get notice that somebody has changed their address, not let us know, because usually that's the only way we would find out anyway. We open it as a complaint and pursue them under the civil penalties matter rather than a fee. So that's the reason for that.
Gotcha.
The next one is an alteration to the non-auctioneer firm license application rule, which I've altered the name of it and provided for what all you had stated you believed should be the responsibilities with regard to a non-auctioneer owned firm and what that principal auctioneer should have to do. Also, you all had expressed interest in having a notification requirement, and I wanted to place that in two places. One underneath this specific statute, and then you'll see at the next one, the notification of change of information is the same notification statute, or the same notification language. and except with the provision that you all wanted that says a non-auctioneer owned firm up in the first rule shall not conduct any auctions until such time as they have an individual registered with the commission as the principal auctioneer.
Okay.
The next one, you all, in our statutes, it is a violation not to have a violation under 6219-112 not to have an escrow account, but it's not actually, or it's a violation to keep the funds of others in anything other than your escrow account. But it doesn't specifically state that you have to have an escrow account, except if you're a non-resident auctioneer. You all had asked for or expressed interest in a rule requiring that they maintain an escrow or trustee account if they're handling money that belongs that comes into possession that belongs to others. So that's a rule regarding that. The proposed new rule of 0160-01-.27 basically expands upon the livestock auction sale exemption that's already in our statute, because that's a very brief kind of exemption, and this is just to expand upon that. Similarly, with 0160-01-.28, the online auctions has been a hot button in recent complaints, and just people calling don't understand. This is to clarify that exemption. Specifically, what you had decided,
This is just the rule that matches the law, is what you're trying to tell me.
Right, it's kind of trying to provide more clarity based on that law. The 0160-01-.29 reciprocity rule deals with the process for a reciprocal licensee, and the second paragraph of that rule addresses the issue that came up with, I believe it was Kentucky, requiring an additional course for anyone licensed in that state, and it basically says that if another state requires a specific additional course to maintain licensure, that then in turn the commission can approve a similar course here. The second, another new rule is 0160-01-.30. It involves military applicants. This is something that all of the regulatory boards are putting in their rules pursuant to a new public act that was passed by the legislature this past session. And the last one is an amendment to a rule that basically said if you're licensed in another state, we accept your education, you accept theirs. And because because if we have that new rule of reciprocity stating that if you require additional course, we can require additional course, I wanted to address there that it would not release them from containing additional education if you all chose to do so under the reciprocity rule over there. So that's an overview of those, and we can go through the analysis that we would need to go through or any recommended changes after the assistant commissioner goes. I know his time is valuable, so I can wait to do the rest of it.
That sounds like a good idea, and we'll do that. We're going to jump off of this, and we'll go back up to our budget report. And we have Assistant Commissioner Bill Giannini in the audience with us today, and we appreciate his attendance in our meeting, and turn it over to you, Bill.
Good morning, Chairman.
Good
board
morning.
members. Really quick, before we get into the budget thing, I wanted to ask about that reciprocity with the adding additional requirements from other states if they do that. Have you all had a specific instance where that's happened?
Yeah.
Not yet. And you'd still have the discretion
Yes.
to do so? Okay. It's really it's one of those things that we had at the Real Estate Commission at some point. Mississippi decided to change their reciprocity, so Tennessee turned around and reciprocated. And I feel like that we should be a state that is leading and not following.
Right.
And we want to do business, and we want people to come here and do business. And we certainly shouldn't let our licensees suffer because somebody in another state did something that we wish they hadn't done, and not as some sort of punishment,
Right.
quid pro quo.
Yeah.
So I would be very. I'm glad that you all are going to have the discretion to
We
look
do,
at these
and
cases.
we've had that discussion before, and we kind of follow the same tone of that. And that our rules are our rules. We want you to. We have tough enough rules to get licensed in this state. We don't need to be tougher.
That's right. That's right. And I think that's a great philosophy, and I think that's one of the reasons this commission does so well. So welcome you all. Thanks for having me. I'm going to try to run through this as quickly as I can. You all should have a copy of your year-end budget close, which actually is the previous 4 years.
That in this right here, okay.
Laying on your,
Is it right here? This mine?
Yes, ma'am.
Where's yours?
And you have two that may look the same. One is your auction recovery fund, and the other one is actually your program. So I'm going to go down first and do your expenditures. And if you start at the top, you can see if you've got the one where it says FY 12-13, your regular salaries and wages were $77,903. Is that what everybody's got in their hand?
Yes.
Very good. All right. You can look at that and see the previous 4 years. It is down from last year, modestly, but down. And it also does include a 1.5% raise that went into effect July 1 of last year. So I'm proud to be able to see that in spite of that the numbers did go down. You can also drop down and look at your travel. It decreased significantly from 21,327. I do believe, and Attorney Kropp and Ms. Whaley will correct me if I'm wrong, I do believe that in 11-12 we had one case that was a significant travel cost.
It was. They brought a bunch of witnesses in for a case that didn't happen.
Correct. That's okay. So attribute the extremely high number that year to that. Then if you drop down and look at your expenditures, I'm going to go straight to the bottom first. Your total expenditures were $148,370. The previous year they were $167,132. You certainly can look over those the categories within and ask any questions that you might have about that. It is, again, down from the year before and the year before that. Not down from 9-10, but I think there were some changes in the accounting methods also from 9-10 until the last year. You can go down to the bottom where you guys will be interested probably and look at net revenue of $238,866, which left your fiscal year balance at $8,066. You guys have had a fairly significant, I guess, a drop and then a flattening of licensees. And so it was something that we very much monitored throughout the year to make sure that we were able to keep you in the black so you would not run in the red. There was a point where I think we feared that you were probably going to end in the red. And thankfully, again, to the good work of the program staff and to Ms. Whaley, that did not happen. So I'm proud of that. I wanted to show you also something we're doing different is we have never, in the past, the programs were never able to see each year what they actually raised in case and complaint revenue. So you can see there that where we've pulled that out before it just went into your licensing revenue period. Now you see at $2,980, that's your case and complaint revenue for the year. So all that to say, at the your balance now, your reserve balance is $164,048, and that has increased. Over the previous year was $155,982. So, and you have a total number of 2,858 licenses.
Where is that?
You actually don't have that on your sheet.
Yeah, I was. That was one of the things I was interested in knowing is, and how our licenses are running from year to year.
Yeah, I'm going to go off of memory here, but I believe now that they've kind of planed out. I see. Oh yeah, Kimberly can help. She can come over and look at this. Come, you sit by me. Pull it out of this report. She wrote it in up here. She did do that. Thank you. So in fiscal year 10, it was 2,967. 11, 2,937. 12, 2,877. So it has.
What's the last number?
2,877.
Okay.
So it has planed out.
And that's total licensees. That's firms, individuals, principals.
Right.
All the above. Okay.
And I believe prior to 10 that it had dropped. Is that? Yeah, I believe that's my recollection. That
Have it broken down just how many auctioneer licenses there is?
we can get that for you, sure. I don't have it in front of me, but I can get it. You're
Well, I'll say this, you know, that's got to be low and as a percentage drop, low in comparison to the number of real estate agents.
oh, no question,
Yeah.
no question, and it certainly is not anywhere near what real estate, who has also finally, I think, planed out. But yeah, it definitely has been much better. Couple things we're doing from the department side that I wanted to share with you all, and this is something we're going to try to do every year. We want to come before you and tell you where you're at financially, tell you what we did with your money, and hopefully praise the staff for taking care of your money all year long. I think that they're doing a great job of making sure that you guys stay in the black. It is very much, aside from the health, safety, and welfare of the public, it is our highest obligation as a department to make sure that we keep you in the black. That's what the legislature expects, certainly. That's what you expect. We are also trying hard to be able to maintain your license fees, that we don't have to, you know, it's a last resort to raise the license fee. We feel like if we work diligently toward keeping your costs low, it will allow you to maintain your license fees, or even maybe in some point in the future reduce your license fees, which we would be very excited about. So we have a new licensing system. I don't know how much of that you all have heard about, but we have purchased a new licensing system for the division. Actually will be used by the entire department, and we expect it to go online the end of next year. It's going to dramatically improve the experience for applicants, for licensees. We're moving toward electronic, paperless operations every day. It is a significant investment, and it's going to be a significant difference in the experience that applicants see.
All the fees be paid online.
Yes,
Yeah.
yes. We are rapidly moving that way. We want to move to electronic communication, electronic notices of renewal, electronic application, electronic renewal, all those sorts of things. We want to get to an ongoing dialogue with licensees and the public about what the board's doing. Have you all signed up for Notify? Yeah.
Yeah, I think we have.
Yeah, okay. And that's another way that we're trying to constantly remain in contact with the licensees, let them know what the board's doing, let them know of, rule-making, legislation, things that are happening that affect their license. And all of it is kind of working toward improving the perception of state government in the public, which is a big priority of the governor's. He has implemented a program called Customer Focused Government that literally every state employee will take a class for Customer Focused Government by the end of this year. I've been fortunate enough to participate in, I think, 6 up to this point with my staff. Ms. Whaley has conducted most of those for the staff. They have enjoyed it. It's been, I think, rewarding on both sides. It's been rewarding for us to see their enthusiasm about it. And it truly is, all of this is part of what the governor's greater vision is of improving everything that we do and understanding, especially for programs like us, you can't go anywhere else and get an auctioneer's license in Tennessee. This is where you got to come. We're not the difference between Kroger and Publix, where, if Publix smushes my bread, I'm going to Kroger. You have to come here. And we could look at that and say, you got to come here. Or we can look at that and say they have to come here, and that's a higher obligation on our part to make sure we're doing everything they can do. And that's certainly how the governor feels. And all of this will fold into that with the new licensing system, the Notify, the customer-focused government. It's all part of it. So
It's 12 months away for that to be
I
implemented.
think we think, yeah, toward the end of next year it should be fully operable is the goal. Certainly that's subject to hiccups or subject to us beating you. Those are things that but I can tell you that the staff, every program is already participating in educating the software people and what their needs are. We're trying to conform things to the system. It's actually, and I've been hesitant to tell people this because I think they take it the wrong way, but it's actually a great-great-great-great-grandson of the system that we have now currently. But it is much improved. It looks entirely different. And the system that we have now was bought in 1993 when Ned McWhirter was governor. So, and I can promise, if I told you guys, hey, you're going to have to use a cell phone that you had in 1993, you would not be happy. And it has really limited our ability, I think, to move into now what the expectation of most people are as far as from a technology standpoint. When we tell people we can't take your credit card or you can't pay online, they're like, what, really? I mean, so those are the kinds of things that we're doing that I think are going to make
Not the same company that's doing healthcare.gov, is it?
No, it is better than that. It is better than, and you know, I'll say in spite of the program has, I mean, all of the programs, and certainly this one does a great job in getting people licensed as quickly as they can. Externally, most people don't realize how challenging that is with some of the system that we have and the things that limitations that we have. So they really do a good job. And
That's great.
like I say, we want to come before you each year and do this. You guys are certainly welcome to ask any questions about anything here or anything else with the program.
I guess we're glad to know these things, but I don't think we feel like we have much say-so over what these numbers are, you know, in terms of,
Yeah.
but it's good to know where we are in terms of that we're maintaining the number of licensees and that we're staying in the black. I guess that's the two bottom lines.
Yeah, and you know, we are, and you certainly do have some input and certainly can ask questions about things that stand out. And I think the main thing for you to know is that we understand that you have limited funds and that we're spending your money as frugally as we can without affecting the service that we're providing to the public.
Fellow commissioners have any comments on that?
Good job.
Appreciate y'all.
Thank you, Commissioner Giannini, for being down here. It's always good to have you here.
Welcome to new member. Thank you. Is this your second meeting? Isn't it? Yeah. All right. So glad to have you. I'm glad to be here. If you guys ever have anything, just don't hesitate to call.
Thank you.
Thank y'all.
Yeah. Let's take a 5-minute break right quick.
Sure. Always be a break.
Probably got to have a deal.
Mr. Herndon?
Not as bad as it looks. It's actually shorter than most times. And I think it's, what page does it start on?
Page 188.
I'll just read everything, and then it seems to be that's what y'all prefer, so I'll go ahead and do that. And then you can make notes and come back to the ones you got questions about. So under the first title, Housekeeping Issues, this case is an old one, 2010-017411. And this matter was presented to the board at its August 5th, 2013 meeting as follows. It's actually the third time. March 31, 2010, notice of violation alleges that liquid MMA was found in a licensed shop. No prior history. You authorized a civil penalty of $1,000. I sent it out as you asked me to. Nothing happened. It eventually made its way to litigation, and then since that time, the inspector who issued the notice is retired and is now not a witness anymore, so we don't have a witness. A recommendation was made to accept to rescind the previous consent order, approve a letter of warning, and close the case, and that's what we did. Strangely, when the letter of warning was received, they sent the civil penalty in, but now we don't have any authority to accept it. So,
Excuse me.
I don't know why it took so long, but the recommendation is approve authority to accept the civil penalty and maintain closure of the case. 2. 2013-003781. The complaint was previously presented as follows. A January 18 notice of violation alleges the shop was open for business. The owner of the shop was performing nail service on a client without a license. And board office records indicate no applications for the shop has been received. Based on that presentation, the board authorized a $500 civil penalty, cease and desist notice. The update is the respondent shop is no longer operating, and this has been verified by the inspector. Board it up. So recommend close the case, flag the file for action if they attempt to reobtain a license. Number 3, 2013-005151. This matter was presented previously as follows. Notice of violation and accompanying inspection sheet alleges the area inspector observed a licensed stylist practicing in an unlicensed shop. The inspector states that there were some sanitary violations. Because the respondent's not currently licensed by the board's authority to sanction the respondent's conduct and assess a civil penalty is restricted to unlicensed activity. That recommendation, the board authorized a hearing and civil penalty of $1,000. The update on that one is that consent order was not responded to because the shop is now operating under a new owner. Recommend close the case and flag the file for action upon any attempt to apply for a licensure by the original respondent. Keep a record on. Second title, new cases. Number 1, 2013-00491. The complaint alleges that the respondent, a licensed cosmetologist instructor, participated in an operation to provide licenses to applicants for a fee and without the applicants completing any educational experience or exam requirements. This activity would violate our statute for revocation. The complaint file contains several affidavits from the applicants that were approached for these proposals, which provide identification, expressions of instructions received that no schooling or examination was required, and that the applicants paid large sums of money for this service. Recommend authorize a formal hearing with authority to settle to pursue revocation of the respondent's license and a civil penalty of $1,000 for each of the 14 affidavits, for a total civil penalty of $14,000. Number 2, 2013-013961. The complaint alleges that this respondent, cosmetologist, purchased required educational hours without actually completing any of the other requirements. This is pretty much his fraud obtaining a license. The information comes to the board office through a member of the public who refused to file a written complaint. A review of the respondent's file does not reveal any inappropriate activity in obtaining the license. There's been no complaint history since initial licensure in 2005. So recommend dismiss the case for lack of grounds for discipline. Number 3, 2013-012911. Notice of violation alleges the respondent in a shop has utilized at least one unlicensed person. Recommend a civil penalty of $250. Authorize a formal. Number 4, 2013-014501. This notice of violation alleges the respondent failed to display proper licenses, failed to ensure all employees are wearing name tags. Authorize a formal hearing with a civil penalty of $500, $200 for each violation. Number 5, 2013-015211. Complaint alleges the respondent in an unlicensed shop has not paid the required fees to relocate the business as of the deadline. No inspection report accompanied the notice, which indicates that a warning was issued. There's no complaint history. So recommend close the case with the letter of warning. Number 2013-009151. The complaint alleges the respondent manicure shop failed to ensure that all employees were wearing name tags and was offering services not authorized by the issued license. Recommend authorize the matter for a formal hearing with authority to settle for a civil penalty of $500. 7, 2013-012781. The complaint alleges the respondent shop failed to ensure all individual licenses were properly displayed, that the shop's wet sanitizer was properly maintained, and failed to properly sanitize and store everything. So approved for a formal hearing with authority for a civil penalty of $750. We'll settle the matter. 8, 2013-012861. The complaint alleges the respondent shop has a fish tank in the premises in violation of our rule against that. There's no inspection report submitted to support it, and there's no complaint history, which means we don't have much of a case. So recommend close the case with a letter of warning because of the lack of supporting documentation. 9, 2013-013051. Complaint alleges the respondent shop failed to properly display inspection reports and to properly label everything. So recommend formal hearing with the authority to settle with the civil penalty of $500. 10, 2013-014171. This is a consumer complaint along with the notice of violation. Alleges the respondent manicure shop was employing at least one unlicensed person Its manager failed to ensure that the shop was in compliance with all sanitary rules. Recommend a formal hearing with authority to settle for a civil penalty of $500. Number 11, 2013-018271. Another complaint alleges the respondent, an unlicensed person, was providing cosmetology services without a license. No complaint history. Recommend issue a cease and desist order and close the case. 12, 2013-017621. Consumer complaint alleges the respondent, an unlicensed person, was providing services, same as before. Recommend issue a cease and desist and close the case. 2013-017201. The complaint alleges the respondent licensed cosmetology shop failed to properly display a sign at its entrance, identifying it as such. The respondent shop is a private residence identified only by an address number rather than a name, which the respondent says that's the name, it's a number. No complaint history for this respondent. So recommend issue a letter of instruction notifying the respondent that the sign must be clear and identifying the establishment. Fourteen, 2013-012141. Consumer complaint alleges the respondent licensed shop has inadequate ventilation and running water. An inspection was conducted shortly after and did reveal that the respondent failed to properly display licenses, failed to display the inspection report, failed to ensure that all trash containers were properly covered, soiled towels were properly maintained and covered, and all products were labeled. Strangely, there's no complaint history for this respondent. So recommend approve the matter for a formal hearing with authority to settle by consent order for a civil penalty of $750. Number 15, 2013-014471. A notice of violation alleges the respondent shop failed to post its shop license. 5 workstations were set up and only 1 person with a license. Board office records indicate that the shop license had been expired since January 31st of last year, and the shop is now out of business. There's no indication that services are being provided at the inspection time, and there's no complaint history. Recommend close the case, flag the respondent's file with the option to reconsider if new information arises. 2013-015171. A notice of violation alleges the respondent license shop failed to post its license or inspection sheet, failed to display all individual licenses, and basically failed to ensure that the place is relatively clean. Failed to clean workstations and failed to cover clean tools. Recommend approve the matter for a formal hearing with authority to settle by consent order for a civil penalty of $250 for each of the 5 observed violations for a total of $1,250. 2013-015181. A notice of violation alleges the respondent licensed manicure shop was employing at least 2 individuals without a license, and that the respondent failed to ensure all employees were wearing the name tags and properly stored towels. Recommend a formal hearing with authority to settle for $750 civil penalty. 18, 2013-015221. A notice of violation alleges the respondent manicure shop was employing at least 1 individual without a license, failed to display all licenses, failed to ensure all employees were wearing name tags, and failed to ensure that everything was sanitary. To recommend approve the matter for a formal hearing, settle the matter with a civil penalty for $250 for each of the 4 violations for a total of $1,000. 19, 2013-014511. Notice of violation alleges the respondent, a licensed cosmetology shop, was employing at least 2 individuals without a license, failed to ensure everybody is wearing name tags. There's no complaint history. Recommend a formal hearing, authority to settle for a total civil penalty of $500. Now we move to the ongoing reciprocity saga. Under the next title, reciprocity cases presented to close. 1, 2013-07921. The above case was investigated for reciprocity issues and was found to be properly awarded, and it's presented to close. 1, 2013-0186331, 2013-01971. Administrative Board Office complaint has been filed against the above referenced 3 respondents alleging fraud in obtaining a license through reciprocity. Upon review of the Board Office records, a letter was sent to the respondents in the reciprocal states requesting certifications, proof of education. All responses requested from the reciprocal states have come in. Each of which license search was made for each respondent listed, and no records were found that indicate any respondent is currently licensed, never been licensed in such states. Board Office records indicate that the respondent's license have now expired. Good. Recommend close the complaints and flag the respondent's licenses file. In the event of reapplication, the respondents must be approved by the board in order to obtain a license. All right. Last heading, reciprocity cases presented for disciplinary action. The numbers are 2013-010161, 2013-010151, 2013-010031, 2013-017071. An administrative board office complaint was filed against the above respondents alleging fraud in obtaining licenses. And it looks like something up. So we recommend refer the cases to litigation with authorization for a formal hearing to seek license revocation for all 4 of them. And that's it.
Is there any discussion?
Could we review number 3 again, please? In the first section.
3 of 18, page 3 of 18. One of the previously presented ones.
This was one that the it changed ownership. Is there not any way that we can prevent someone else going in under a new name when the actual site was disapproved?
Make every effort to do that. This is one of those rare cases where the succeeding person has no connection to the previous one, and the previous one doesn't seem to exist, at least that we can find. I'm sure they exist. We just can't find them. If they do crop up again and try to apply, then we'll have them then. I know what you're saying, though. It's a phenomenon where they just switch owners between a particular group. That's not the case here.
Can I ask a question also, Mr.? Go ahead.
We're on that note, the new system that we'll be getting is going to help us tie identities and do some cross-checking like that we're unable to do, to kind of help with that.
On page 7, case number 5, unlicensed shop is not paid the required fee to relocate the business as the deadline as of September 30th, 2012. No inspection report accompanied the notice of violation, which indicates that a warning was issued. There's no complaint history.
Yes, the only thing that I have violation. See, the thing that really anchors our case is the inspection report. That's the document that you give to the shop. The notice of violation, and they circle warning. To me, that indicates that they didn't cite them for anything. They just issued a warning. So there's really nothing for me to travel on. If I had an inspection report and they marked that they violated a particular thing, it would be a much stronger case. And that's why I recommended a letter of warning in this case.
Okay, thank you. Are there any other questions?
Yes, I wanted to ask about number 8. about a fish tank. No inspection report submitted in support of the allegation.
Right, same.
Wouldn't, couldn't an inspector go in there and see where they've got a tank or not?
Well, no comment. You would think they
No
could.
comment.
I think they should be able to.
Well,
I think they should also issue an inspection report and mark that as a violation, but they didn't. They didn't submit an inspection report. They sent a notice of violation with no inspection report, which again, that's our case. What I'm hoping to do is next time they inspect this particular shop to make sure that we get an inspection report that has that marked on it.
okay, so that means until you get an inspector that's just gonna go in and maybe not mark that, then it's okay?
Not okay, but it's very difficult to prove in a formal hearing.
Not send another inspector if that one is not doing it?
Yes, we can.
Okay.
That's a remedial
Well, that's-
measure that I've certainly thought about.
Sure.
It's just in this particular case that I have to work with, there's just nothing in there for me.
Any other comments or questions? If not, do I hear a motion that we accept the recommendations?
Madam Chairman, I make a motion that we accept the recommendations.
Motion made by Mr. Herford that we accept the recommendations. Do I hear a second?
Second.
Second by Ms. Ali. All in favor say aye.
Aye.
Opposed, nay. Ayes carry. And I was told at break, we being the board members, have to speak into our mics louder.
Next is the consent orders for the month of September, or October, I'm sorry. We have a total of $2,500 in consent orders for the month of October in front of you.
I hear a motion we accept.
Move that we accept the consent orders.
Motion made by Ms. Ali that we accept the consent orders. Do I hear a second?
Second.
Seconded by Ms. Coopinger. All in favor say aye.
Aye.
Opposed, nay. Ayes carry.
Next on the agenda, we have just an update on the rulemaking process. Rob will answer any questions you may have. I do have the draft copy that we looked at last month in case anybody wanted to look at anything again. We haven't made it.
One thing that I made a change on based on last time's comment was on page 3, and it was item G. There's one wet sterilizer at each student workstation. I don't think it's reflected on yours, but we struck out at and put for each student, and then struck out workstation.
Sorry, what page was that?
Page 3,
Okay, you did what now?
on item G in the first rule amendment, where it currently says one wet sterilizer at each student workstation. There were comments that we should strike out the word at and put for, and then strike out workstation, so what it will say is one wet sterilizer for each student.
That's for G.
I don't think that's reflected in what you have. That's the only thing I marked on here that I didn't get.
And it was based on your conversations?
Yeah.
Ms. Huckabee. Does anyone need a copy?
You mark out under number 2, the G, under number 2, the electric heating mask?
Yeah, the copy I have's got a line through it.
Oh, that's right. You're correct. I'm sorry.
This is what we call a red line version, even though there's no red in it. But it shows you that everything that's struck out is to go away, and everything that's underlined is new. take a look, I'll explain again how rulemaking works, just so you'll know what the next step is.
Can you repeat what you just said?
After y'all take a look at the draft there, I'll explain the rulemaking procedure so we can be familiar with what the next step is. This is a protracted procedure. It takes a long time. Lots of different people have their hands on it.
Roxanne, I know this is not what we're on the subject at this time, but in our minutes, a schedule for, this coming year, the 2014.
Yes, ma'am.
The December, I think that's the one that should have been the 1st instead of the 8th that you've got down.
He was gonna check. That was in June.
June has changed. They're already posted online. June, I had it the second Monday instead of the first Monday. I think
Okay,
June
but
was-
on the sheet that was in our packet, look at December.
Okay.
The only other thing I think, I can't remember if we mentioned this last meeting or not, but on page 4, under the number 3 item, the floor space,
Yes.
we just kind of, I thought that was really vague, and I didn't know if we needed to be more specific or.
Well, I think that came about because we don't want people to use hallways and some of the things we've been seeing that were questionable as far as what they're really instructional space. But yeah, you can be as specific as you want. But
I don't know what I would change it to at this moment, but
Uh,
it says adequate instruction floor
Yeah.
space, and that's.
that would mean it would be a case by case for you when they brought it to you if you decide it's adequate. We don't want to make it so restrictive that it's tough to meet, you know? Because sometimes when you're looking for a place to put a shop, you have what you have and little flexibility in it. You just can't use hallways, like exits and things like that.
So can that include the clinic floor ever, or should it say not to include the clinic floor?
Well, the things we're saying it doesn't include are storage, restrooms, utility rooms, passageways, or inhabited administrative spaces such as reception areas, offices, and break areas. Those are the specific things we've listed. And it says shall not include such spaces as, so you could consider other spaces. It's not limited to that. Pretty much things that are obviously not instruction space.
On page 5. Yes, sir, on page 5, number 1 and number 2, I need a little more explanation on those. To me, it's not specific enough. Apprenticeship student means a student enrolled in a school participating in apprenticeship program with the intention of completing the school curriculum under the school apprenticeship program. What does that mean, under that school apprenticeship program?
Offers both apprenticeship and standard, and make sure that the student that's under the apprenticeship pathway is identified as an apprenticeship student. That's all that means. Two different pathways to graduation.
Under number 2, it says the supervising licensed professional will provide the participating school with the student apprenticeship activity record. Does that mean that the board's got to make an activity record?
Have to do a couple of forms, probably, one of them being this, so that the person that we're calling a supervising licensing professional has something that they can complete. We'll provide the form like we do an application when you get a new license. It'll be something we'll put together, yes.
Would you like to explain the next procedure, Mr. Herndon?
This is one of the longest things that boards ever try to do, is write rules that it can literally take at least a year, usually longer than that, because there's so many statutory waiting periods that are built into it. What we're doing now is trying to come up with a, I hate to say rough draft, but at least a draft of how we think we might want the proposed rules to look. After we get it sort of the way that you want to see it, then I have to send it through all the approval chains in this department and the Attorney General's office to get approval, and the Governor's office to move forward with them and to get a hearing date. After I get approval for a hearing date, I got to come back to the board and propose a regulatory flexibility analysis for you to review and approve. That has to be done prior to filing the notice. So how many meetings is that?
4.
After that, we have to come back and get you to approve the notice to give me permission to file it. After we file it, it takes 50 days, business days plus 5 actual days in the future to set the date, wherever that happens to fall. After that, we have the actual hearing, which is open to the public, because that's how laws are made in the legislature. That's how we make rules here. It's open for public examination and debate. At that time, the proposed rules we're not married to. At that time, after we hear public comment, we can adjust them the way we feel we have to. After that, I send them to the Attorney General's office for review of legality, so they can tell us that we're able to do what we want to do. And after they send it back and forth to me a few times, I file it with the Secretary of State's office. And it has to sit there for 90 days at a minimum, which is 3 months. After that, we have to go up to the Government Operations Committee of the General Assembly and explain the rules to them and answer any questions they have, and they have to approve them because the legislature has the final say. So at the best, I don't know, a year or more. And at that time, this legislature will go in session before too long. And they may do something that's going to change, well, everything. We may have to completely redo these, either eviscerate them or alter them. if they do something that impacts what we're doing here, because they'll change our statutory authority. So I'm not gonna cover it up. It's gonna take some time, and I'll keep you informed, because you're gonna see the drafts like you're seeing now. The commissioner's office may have something to say about it proposed, and then you'll have to look at what they have proposed. Well, maybe you should do this and that. So I can't tell you it's going to be quick, because it ain't. Even in the best of circumstances, it's going to be next year late, or maybe, I don't know when it's going to be, before they're effective.
Someone could have a baby before that was done.
Send them to school.
Is there anything else?
All these safeguards are built in to make sure that we do it right and protect the public. So.
Nice.
Is
Courtney, you may be the only one living long enough to get to the end of this.
Is there any other business to come before the board? If not, it's tradition. New board member has to make a motion. Motion's been made by Ms. Courtney to adjourn. Do I hear a second? Second by Ms. Ali. All in favor say aye.
Aye.
Opposed, nay. Happy Thanksgiving. Adjourned.
Thanksgiving.
We've never gotten out this early.
Welcome.
Gee, I'm not starved to death yet.
Call me Merle.
It's not done. It goes to formal hearing.